in which case, good afternoon, everyone. It's a little bit after 2 o'clock on Wednesday, the 5th of March, 2025, and time to begin this pre-examination meeting for the proposed Carr Dubh wind farm DPA reference WIN-130-10. And before I go any further, can I just check that everyone can hear me okay? Thumbs up? Yeah, or nod? Perfect. Thank you very much. I think you all are, but during the meeting, it'd be ideal if participants keep your cameras on, but keep your microphones muted, except when you're speaking, just to make sure that everyone can hear what's being said. My name is Philip McLean. I'm a reporter with the Planning and Environmental Appeals Division, or DPEA. I've been appointed to undertake the examination of this application submitted under Section 36 of the Electricity Act 1989. The application is for a proposed 13-turbine wind farm. I'll prepare a report to the Scottish Ministers on the application, and it will then be for them to decide whether or not to approve it. I'll be taking note of the matters discussed at this meeting as we go through, so please bear with me if I need to pause for a moment to note something down, and a formal note of this meeting will be issued within around a week after today. You're probably all aware of this, but I'll just run through. This meeting concerns the arrangements for any inquiry and associated procedures necessary to consider this case. It does not form part of the inquiry itself, and no evidence on the merits of the proposal will be heard today. I circulated the agenda just over 2 weeks ago, and so you will have had the opportunity to consider my current thinking. I would hope to be able to progress quickly through the agenda, particularly on matters where parties are in agreement, and with some discussion on matters where there are different views. A few initial housekeeping matters just to run through. This meeting is being recorded and broadcast live, and Rebecca Davidson, who's the DPA case officer who you've seen already, she'll remain online in case of any technical difficulties, but hopefully that's us plain sailing from now on. In due course, the recording will be available to view on our website. In accepting the invitation to this meeting, you have agreed to being recorded and to the use and storage of images and sound recordings and any information contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. So I'm sure participants are familiar with this platform. There's not very many of us, so hopefully you've all got a view where you can see all parties participating. I'll do my best to keep an eye on everybody, to watch for anybody raising their hand or waving, and please do that if you want to attract my attention, and please ensure mobile phones are on silent, please. So I don't anticipate today's meeting will be particularly long, so I haven't planned any formal break, but I can review that if we take longer than anticipated. So moving on to item 2 of the agenda, I'd like to invite the lead participant for each party present to introduce themselves and the members of their team. And it would also be helpful if you could indicate, if you know at this stage, if there are other witnesses that are likely to be involved in the process going forward. So I'll start with the applicant's team, please.
Good afternoon, sir. My name is Colin Innes, and I'm with Sheffield Wedderburn solicitors, and this afternoon I appear on behalf of the applicant. I'm accompanied this afternoon by Mr. Scott Balance of the applicant, and also Anna Brenstrom of my firm as well, who will be undertaking the support in relation to this process. In terms of other witnesses, it's identified that there are likely to be required to be discussion in relation to landscape and visual matters, and that will be dealt with by Sam Oxley of LUC. In addition, in the outline, you've identified, sir, the potential hearing session on energy and planning policy, and potentially draft conditions. David Bell of David Bell Planning would be our potential witness. Insofar as any of the landscape and visuals also include discussion of design, present to be able to, at a relatively high level, talk about constraints, but it's not envisaged that we would bring every single expert who was involved in that site selection process to any such hearing. It would more be somebody who could highlight which other constraints had influenced that particular locations. And in relation to matters pertaining to ornithology, it would be Howard Fern would be our potential witness at any hearing in relation to those matters. So, thank you.
Thank you. That's very helpful. Can I turn now to the council, please?
Good afternoon, sir. My name is Maurice O'Carroll. I'm a member of the Scottish Bar and English Bar, and I'm representing Argyll and Bute Council. I'm joined today on the call by Susan Mayer, my instructing solicitor from Argyll and Bute Council, and also by Arlene Knox, who's an officer within the planning department of the council. Arlene will also be a witness in relation to the conditions session when we come to that part of the inquiry. At the moment, things are still potentially fluid for reasons perhaps I'll come on to explain in relation to who will be present for landscape and visual impacts. Although at the moment that is intended to be Carol Anderson, and I very much hope that will be the case. And the matters with regard to planning policy is perhaps something that will be advised later.
Thank you very much. That's very helpful. There are no other parties who have opted into the inquiry process, although of course other parties or members of the public may be watching this meeting online, either live or at a later date. So just before I move on, are there any preliminary questions or other issues to raise before we move on to the next item? No. Okay. So item 3 is the code of practice for handling inquiries. I dare say this is probably familiar to those in the meeting, but I am just mindful that there may be others watching this, so I will just briefly run through it. There are no detailed procedural rules for the conduct of inquiries under the Electricity Act. However, DPA has produced a code of practice modelled on the 2013 Planning Appeals Regulations, and I expect to apply this code in this case. A link to that was provided in the agenda for this meeting, and it's available on the DPA website. I'll also include a link to it in my notes of this meeting. So the code allows for flexible procedures, with each issue being dealt with by the most appropriate mode of examination. This could be an inquiry session, a hearing session, or further written submissions. On some issues, sufficient information will already have been submitted and no further procedures will be required. When I write the report to Scottish ministers, I will take account all the environmental information submitted by the applicant and all consultation responses. In this case, there are no public representations for me to take into account. The type of procedure being followed or the absence of any further procedure on a particular matter is not an indication of the importance of that issue. So just briefly to run through the options in terms of process. An inquiry session is where each party is invited to present evidence in turn, and this is subject to cross-examination by those with an opposing view. Usually parties are legally represented and lawyers will do this questioning of the witnesses. The reporter, myself, would also ask questions. Inquiry sessions are more formal than hearing sessions and are particularly suited to topics with a lot of technical evidence. A hearing session is a structured discussion led by the reporter based on an agenda that I would issue in advance. There's no formal leading of evidence or cross-examination. Parties' lawyers can take part in the discussion, but there's no need for legal representation, and hearings are generally less formal than inquiry sessions and are suited to issues where there are differences of opinion of a less technical nature. Further written submissions are simply me as reporter asking parties to provide certain information and inviting other parties to comment on that. Site visits are also part of my evidence gathering, and we'll discuss those later. And you'll be aware all parties involved in inquiry or hearing sessions need to prepare and submit their case in advance to allow other parties to see what evidence is being presented and avoid any surprises on the day. So my agenda and the appendices is where I've already set out how I think the case should proceed, and we'll come on to that shortly. But before I move on, are there any general queries on the code of practice and the options that it offers? No. Okay, thank you. So item 4 relates to any updates to parties' positions, any information that might be necessary to update the application And I've noted in the applicant's position statement from November 2024 that it wishes to submit a short additional statement regarding maximising economic benefit. As I've set out in the meeting agenda and appendices, I have suggested that I could request further written submissions on this matter, which we can discuss under the next agenda item. As parties will likely be aware, updates are subject to publicity and consultation requirements under Part 6 of the EIA regulations in certain circumstances, depending in particular on whether they constitute substantive information about a matter to be included in the EIA report. So I will need to take a view on this in relation to any updated information that's provided. At this stage, it would be helpful for me just to hear a bit more about the intended scope of this additional statement regarding economic benefits, and in particular, whether the applicant anticipates it would involve any change to the assessment of significance in the socio-economic chapter of the Environmental Impact Assessment report. Could I ask the applicant to comment on that, please?
Yes, thank you, sir. I think the proposal is actually to do something pretty more limited in context, which was just to bring it all together. There's no startling new information that we're hoping to reveal in this statement. It was more just a recognition of that it come up elsewhere in the context of other inquiries, and we felt it might be useful to consolidate our position in advance rather than waiting for to appear in the perhaps the written evidence of the planning witness before the hearing. So it was one matter we felt that could do with putting together really rather than anything substantive. But I do have one other matter to raise with you, sir, and that is the visualizations that are depicted in our environmental impact assessment reports are of Blair Gower at a scoping stage. And they equally, when they produced their variation application, also put forward the scoping stage of our application. And therefore, you have two sets of visualizations that have the correct images of the particular projects, but they are over-egged in respect of the adjacent projects because they're both scoping projects, and therefore, as the both projects were refined, those are not reflected. Now, there's two ways we could deal with it. One is obviously you could have the Blair Gower visualizations lodged, very similar viewpoints used, and it actually isn't that hard. I've done the exercise. It's not that hard to look at both. Or alternatively, we could produce, at your request, some updated images that reflected the accurate picture between the two in relation to key viewpoints that are relevant to this public inquiry. And in that context, again, I don't view this as new information in the sense of the Scottish ministers do have both sets of information before them and already have considered the Blair Gower position. And against that context, if you requested it under Regulation 20 of the Electricity Works regulations, that effectively it's information provided for the purposes of an inquiry, that's correct. Secondly, that if the written requirement for the information states that it is to be required for it, then it meets the second threshold of subparagraph 6, and where the information is required to be publicised as part of an inquiry, well, it would do so. It would become part of the public record by being published. I think it was important for us to set that out to you, because otherwise, potentially, you might have been led into a position where you did not have the precisely accurate position. And I think it is important that you had the right material for both these applications. As I said, we're quite prepared to produce it, but we feel that mechanism is appropriate in these circumstances, because, as I say, the information from all the viewpoints is publicly available already. All that we would be doing effectively is making it combined together. And as far as we're concerned, it's not going to lead to any differentiation in assessment of significant effects arising from this proposal. And we would not be proposing to lodge further material in relation to assessment. But it does not make that difference in terms of proposal. So, as I say, I was keen to make sure at the earliest opportunity that you were aware of that particular point, because it's a narrow one, but it's one that we should get right. And secondly, if that material is to be requested, it would take us till the 7th of April to produce. The week commencing the 7th of April is the earliest timescale we can actually physically produce it. But as I say, it would be, the information's already out there. I know Carol Anderson, on behalf of the council, has also assessed the Blair Gower proposal. So she is already familiar with its information and has also considered our information. And knowing Ms. Anderson, I'm sure she didn't find too much difficulty in understanding the respective positions having that material. So it's not as if this would be something which would be a surprise to the council, because they've already had to address looking at both environmental impact assessment reports, and obviously their potential witness has already advised on both and considered both sets of material. So there's nothing really new coming out of it, but it's whether it would be easier for you, sir, in doing your work that you have to do, to have essentially a single set of documents that you can utilise, and that's probably the best way of putting it.
Okay, thank you. I'll ask the council to come in with any comments on that in just a moment. But just maybe to clarify from my own understanding, I had noted from what I've read so far that the Blair Gower had been approved at a certain height and was at the time of the assessment at scoping for a different height. I don't recall the number of turbines. Could you just briefly outline the difference between what's been included as the scoping stage in the existing information versus what it would be that you're proposing, and also what stage that proposal is now at?
Yes, Colin, yes, that proposal, the Section 36C variation, which essentially was an application to increase tip height, but actually reduce the number of turbines from 17 to 14, was granted Section 36 by the Scottish Ministers on the 9th of August last year. So it is now essentially a consented scheme. There was a previous application that had been granted for 17. So essentially the variation was to reduce the number, but to increase the height. Whereas we had the 17 turbines in our images, because that was the scoping layout at the time. So that's, in essence, Blair Gower has reduced the number, is the key for us. And as I say, that's the current position. So it's been consented. So we've got that's now a firm position. So we can produce the firm consented position together with this application. And that's really what's proposed.
Okay, thank you. Can I ask for the council's views on that, please?
I think, as Mr. Innes has outlined, it really is a matter for you. If you consider it appropriate and it's something that would assist you in making a determination, then I think it'd leave matters in your hands. So.
Okay, thank you. That's helpful. I'll give some thought to that and confirm in the note of the meeting. But thank you for outlining that.
The only other, sorry, I meant to add just one other thing.
Yeah.
I did note that the likely date for producing these additional visualizations, if they are to be ordered by you or requested by you, is the 7th of April. And for reasons perhaps we're going to come on to, I would just hope that would not have any impact on the overall timings of the inquiry. No, Mr. Innes is shaking his head, so that's fine. It appears to be a non-concern, so I'm glad I flagged it, but I'll leave it there.
Okay, thank you. I'm conscious, I don't think I've asked the council just if it has any comments on the point about the economic benefit statement as well, just before we move away from that point.
And again, sir, if Mr. Innes says that it's simply pulling matters together and introduces nothing new, I'm perfectly happy to accept that and have no objection.
Okay, thank you. Thank you very much. That's helpful. From my initial review of the case, I'm not aware of any other updates that would be needed. Just one minor point to highlight that I've picked up, that the Argyll and Bute Local Development Plan 2 was adopted in February 2024, which was after the application was submitted in March 2023. So I would expect statements for any policy hearing to address the up-to-date position. Are there any other comments on item 4 in terms of updates before we move on?
Yes, there is just one thing. It might be a good time to mention it now. If I refer, well, the report to committee, I don't need to take you to it. It's just a very brief matter. In the report to committee, it is noted that in respect, there are outstanding trunk road matters, and that I think there's a final position of Transport Scotland is still required. And I think that might be as well just to flag that now as potentially being something that could possibly be updated if that's in the applicant's knowledge.
Well, invite the applicant to comment. My own understanding of that from my initial review is that subsequent to the date of the Council's committee report, there's further responses from Transport Scotland withdrawing any outstanding objections, but perhaps the applicant can just confirm if that's correct.
Yes, so that's our understanding of the position. It matters where it's on the committee.
Thank you. Nothing else, Guy. Thank you.
Okay, thank you very much. So we'll move on then to item 5. And as mentioned already, Appendix 1 of the agenda set out my initial thinking on the topics to be addressed in my report and my proposed methodology for dealing with each subject area. After the agenda was issued, I've also indicated to parties that I'm considering whether to schedule an additional hearing session. So I think we'll just run through the suggested topics in turn and seek comments, starting with landscape and visual impacts, which I've suggested should be addressed through a hearing session, which I believe accords with the preferences of both parties set out in your position statements. Visual impacts are the main focus of the Council's objection. It would be helpful if parties could also set out the landscape context for their positions. I would prepare a hearing agenda nearer the time after hearing statements have been submitted. However, the likely matters to be considered in the session are set out in Appendix 2, and as has already been alluded to, they include design considerations to the extent relevant and technical constraints insofar as they're relevant to this topic. So I suppose 2 questions. Firstly, whether parties are content with this approach and whether there's any comments on the provisional scope, starting with the applicant, please.
Yes, thank you, sir. We're content that the landscape and visual objections raised by the Council are relatively narrow in nature. They're also fairly specific, and that, in essence, I think allows a hearing to be the best format for resolving the matter, in the sense of we're not having to, debate large tracts of background documentation, because that's not really where these particular criticisms are made. Of course, we'll provide the context, and noting that you will need that, but insofar as the actual differences are concerned, they are very narrow in nature, and in that context, we're very content with the matters that you've set out, and that we are confident that at least one of the latter matters relating to the activated lighting can be resolved by us agreeing a condition with the Council, and a not dissimilar provision appears to have been imposed on the scheme as well. So there'll be a consistency in that regard. So yes, we agree with the process. We agree with the topics, and as I say, the nature and extent of disagreement is narrow, and that's also reflected in findings of the EIAR in respect of significance, where again there is not. This is largely directed at. This is the end consequences of design and how it looks. So, as I say, we're very comfortable with what you've proposed. So thank you.
Yes, thank you very much. And the council, please.
Nothing to add, really. The council's content with that mode of investigation by way of a hearing, and I concur with what Mr. Innes has said. The scope is very limited and specific, and the topics that you've outlined are adequate to cover everything that to be discussed.
Okay, that's great. Thank you very much. So moving on, I've also suggested a hearing session to discuss applicable energy and planning policy and its implications for the proposal. So again, just to confirm whether parties are happy with this approach, starting with the applicant.
Yes, so always potentially useful just to catch up. It's not a key dispute area between ourselves and the council, but clearly there's matters that arise, and we continue to get new policy coming in. And as you say, our planning statement didn't read where the local development plans got a different status now. So we would want to address those matters, and clearly the hearing would be an effective means of at least testing some of the policy should you want to do so. So again, very comfortable with what proposed and the topics.
Okay, great. Thank you. And the council?
Again, agreed.
Great. Thank you very much. Okay, moving on. So as set out in Appendix 2 of the agenda, I propose that the applicant should liaise with the council to prepare a set of draft conditions which should address relevant mitigation measures identified in the EIA. And in addition, explanation should be provided as to how they address applicable matters raised in consultation responses and written submissions. And purely as an example, I note that SEPA's most recent consultation response indicates its position as one of objection unless a planning condition is attached regarding deep peats and access tracks. So we can discuss the timetable for submitting draft conditions in a moment. But again, it would just be useful for me to confirm that the parties are content with that suggested approach of preparing these in advance and considering them in a hearing if full agreement is not reached. Start with the applicant.
So just to say, yes, thank you. So we fully agree with the approach. We would hope to make very considerable progress. We have prior experience of dealing with the council and the very constructive way in which they generally deal with these matters. So, as I say, what we will hopefully get is a set of conditions with a relatively any narrow areas of disagreement explained. And equally, we're also conscious of the fact that new draft conditions have recently been published. So that's helpful and can be the starting point of the drafting. So again, we've got a good head start, and that just leaves usually a relatively short session on any matters that you might want to have explained or alternatively differences. So absolutely, I'm very comfortable with what you propose.
Thank you. And the council?
I have nothing to add. Thank you. Agreed.
Okay, that's great. Thank you. So moving on to ornithology now. In the agenda and appendices, I suggested that ornithological issues, in particular relating to golden eagles and white-tailed eagles, could be addressed through the use of further written submissions. And as explained in Appendix 2 of the agenda, this could focus on a response by the applicant to the comments set out in the most recent consultation response from NatureScot. And I would then seek NatureScot's views on the submission, as well as any comments from the council. After the agenda was issued and having reviewed this matter further, I indicated I'm considering the possibility of scheduling a hearing session on this topic, really in case that further written submissions do not provide me with the necessary clarity and I have further questions. That might be a good way of resolving it. And NatureScot would be invited to participate in this session. So I suppose my question is whether parties are content that this matter can be addressed through written submissions in the first instance, but with a hearing scheduled to explore parties' positions in more detail if I ultimately consider that that is necessary for me. The applicant first, please.
Yes, sir, we agree with your approach. Just to give some context to that in relation to the access track issue that arose whilst the matter was raised in the original letter for NatureScot, there was what can best be described as there wasn't a full understanding of which particular Nest was being referenced in that response. And indeed, it was only really in April of 2024 that we got the information. And this partly arises because I think, as we've already experienced, these issues, the information is all confidential. And what had happened in this particular circumstance is NatureScot had been given information by a third party. And as I understand it, in that context, they treat that information as confidential. So there was an element of cross purposes at various points as to what Nest was being referenced, but that was clarified in April of that year. And we, having looked at that situation, agree that if the Eagles were to use that particular application, then it would be within the disturbance distance of the access tract. We therefore will be proposing a condition to deal with that matter, and hopefully that will respond to NatureScot's concern in that regard. And yes, we're happy to come back on the 3 points raised, and hopefully the written exchange will allow those issues to be more focused should a hearing happen. So I think it's really very sensible to have an exchange of written information, and that will then help to refine actually what points might require to be considered if need be at a hearing. So again, we agree with the proposal and agree with the framework of trying to at least explore narrowing the issues through written exchanges with to you and through NatureScot. Thank you, sir.
Okay, thank you. Does the council have any views on this point?
No, as you'll appreciate from the reasons for objection, this doesn't form part of the council's objection. Council will defer to the expert opinion of NatureScot and wouldn't intend participating in any hearing session where ornithological issues are discussed. Leave that for NatureScot and the applicant.
Okay. Thank you. That's very helpful. So moving on, as set out in the appendices, there's one other matter which we have already alluded to already, where I've suggested further written submissions might be appropriate, which is the applicant's wish to submit further information on maximising economic benefits. So that would enable the applicant to provide that, and the council would then be able to comment. The note of this meeting, which will be issued next week, will confirm the topics that I'm seeking further written submissions on, and it would normally serve as the formal request for these, and we'll discuss timescales for responses under a later agenda item. Just to flag now that in relation to ornithology, I may need to take a bit more time to read and digest the information that's before me, to help me frame a request for further written submissions in the most effective way, to ensure that I get responses giving me the clarity that I need. So it may be that that request is issued separately after the note of the meeting. It will, just to be clear, also be open to me to request further written submissions on any other matters at a later date if it subsequently appears to me I need further information on a particular topic to help me write my report to ministers. So in Appendix 1 of the agenda, I've set out a number of issues that I consider can be addressed without further procedure, and I'll consider in detail the information that's already been submitted on those topics and issues. I won't go through them all in detail, but I'll just briefly list them and then invite comments on whether there's any contrary views on any of them. So the topics are other ecology matters aside from ornithology, which would include fisheries, hydrology, geology and peat, cultural heritage and archaeology, traffic and transport, noise and vibration, aviation safety, telecommunications and forestry. So can I just invite each party to confirm if it has any comments on those matters being subject to no further procedure, starting with the applicant.
Thanks. So we have no issue and agree. Thank you.
Okay, thank you. And the council?
Same.
Thank you very much. And just before we move on, are there any other significant matters that I will need to address that we've not mentioned so far, or have I captured everything? The applicants?
There is nothing that I'm aware of that you need to be aware of, because if we were, we'd be letting you know, as we were with the visuals. There's nothing that we're aware of that we're
That's
particularly
fine.
concerned about or bearing matters. Thank you.
Okay, thank you. And from the council?
And nothing from the council.
Okay, thank you very much. So we'll move on now to item 6 on the agenda, which is the dates and formats and location, etc. of the oral sessions. So in terms of format, I've suggested that sessions are held virtually in the interests of efficiency, having regard to the fact that there are only 2 parties opted into the process and there are no public representations on the application. In line with our normal practice, we would also intend that sessions would be webcast, so that would enable any other parties to view sessions online and follow what's going on if they wish to do so. So first of all, can I ask whether the parties agree that virtual sessions would be appropriate in this instance, starting with the applicant, please?
Yes, sir, we're comfortable operating in the virtual format. Thank you.
Okay, and the council?
Yes, sir. Happy.
Okay. Thank you very much. That's helpful. So turning to dates, I believe from earlier informal correspondence that both parties are able to accommodate sessions taking place during the week commencing Monday the 9th of June, other than Friday the 13th in the applicant's case. So for the purposes of the notes, or if there's any difference in that, maybe I'll invite you to come in.
I think perhaps it might be appropriate for me to go before Mr. Innes.
Yeah.
Since matters were informally agreed or discussed with you and the case handler, I've been in discussion with the landscape architect for the council, Carol Anderson. Carol Anderson is actually the author of or provided the opinion which led to the comments within the report to the committee, which in turn led to the objections to the scheme. So Carol Anderson is very, obviously you'll probably appreciate, very long-standing landscape advisor to the council. Now, the position with her is that unfortunately the previously mooted date of 9th of June, I'm afraid she's not available for that. And I noted from earlier correspondence prior to things moving around the 9th of June date that it had previously been mooted, that there would be perhaps the possibility of the final week in May would be available. And in an email from Rebecca Davidson dated the 6th of February, the applicant had indicated at that stage that they were available for hearing sessions for the inquiry during the week commencing the 26th of May. So the position is that in terms of Miss Anderson's availability, she is in fact only available on the 28th and 29th of May, and she's not available in June. So for the reasons which I've already outlined and the importance which she would have and how beneficial it would be to have her as a witness as opposed to anyone else, then I would seek that we have the landscape and visual evidence on one or other of those days at the end of May. I should also add, I've discussed this informally with Mr. Innes.
Okay, thank you. Yes, certainly aware that that week had been another potential week. And Mr. Innes, can you confirm that that date would be acceptable to the applicant as well? I think you're on mute at the moment.
Yes, we've been scrabbling around again today, and we can definitely do that. And I think in light of what Mr. Carroll has said, I think there is a lot of advantage in having Ms. Anderson come and speak to essentially the evidence, because she was the one that did the original assessment. And I think, when we're trying to make this process as effective and as efficient as possible, it probably wouldn't be as effective or efficient if the council had to go off at this stage and find somebody else to do the same work. So we're certainly keen to accommodate that, to manage it, and probably in terms of, it's all about timing. I mean, we would anticipate the landscape and visual material should not take more than a day. So I think we can commit to saying that would be on the 28th potentially. equally, the policy session and conditions should be capable of being easily accommodated within a day. And then the holdover for anything ornithological, we could hold it on the Friday the 30th, or we could hold it to a date in June the 7th, which you have already indicated might be a date to NatureScope. But that is obviously up in the air. At this point, what we do know is Carol Anderson's availability is such that we really need to probably fix a day and make that happen, or otherwise it looks like there would be problems in terms of timing, because the next timing is into July, and that's quite frankly not easy, as I suspect we'll never get everyone together in July. So I think in light of that, probably suggest the 28th and 29th are fixed for those particular sessions, and if needed, we try and work around a date for possibly the Friday, or alternatively the week, one of the days in June, for a hearing if necessary on the ornithological matters. And at least then we have something fixed. We can all work to it, and you can work down the timetables. And I think that should work. So hopefully that's the disposition. Thank you.
Okay, thank you. That's helpful. Just in terms of the ornithological session, we have written to NatureScot about its availability. As far as I'm aware, we haven't heard back yet. So hopefully we will hear back, ideally before the note of this meeting is drafted, but otherwise we may need to revisit that date further down the line. But okay, that's helpful. That looks like we're homing in on the 28th and 29th of May then. In terms of the time needed, it's been touched on already. Certainly my preliminary assessment was that a landscape and visual session might be around a day, and that hearings on energy and planning policy and on conditions could be covered within another day or possibly less. So I'm seeing nods from Mr. O'Carroll. I take it that that's agreed, that 2 days for those matters, and then a further date potentially for ornithology would be an appropriate amount of time. Okay. So that's useful. As best I can, subject to hearing back from NatureScot, I will confirm the timetable for the sessions in the note of the meeting. So, unless there's anything else that anybody wants to raise on that, we'll move on to item 7. Okay. Item 7, just in relation to documents, and then the timetable for submission of statements, etc. In terms of core documents, as set out in Appendix 3 of the agenda, we prefer to work to a single core document list managed by one party, usually the applicant, with the cooperation of other parties in preparing this and making documents available in accordance with the agreed timetable. In the past, core document lists have sometimes become very long, and we're really trying to get away from that, and would request that the list should be restricted to those documents parties expect to refer to in the oral sessions or to rely on in evidence. Our preferred method for the submission of new documents is the file transfer tool Objective Connect. We would set up a workspace to allow transfer of documents and would issue invites to parties in due course. Documents will also be available on our public website for anyone to access, obviously except where there's a particular need for them to be kept out of the public domain, such as certain sensitive ecology or ornithology information. So documents that we already hold need not be resubmitted, and instead hyperlinks to the documents on the DPA website can be included on the core document list. And I will issue more detailed guidance on the core document list and Objective Connect alongside the note of the meeting. So just for today's purposes, firstly, is the applicant content to manage the core document list, and is the council content with that approach? Start with the applicant, please.
Yes, so we'd be happy to coordinate that, and I, for one, certainly agree with your sentiment about trying to make core document lists documents that are actually referred to, as opposed to every single document that's ever been on the topic, which it just makes the whole preparation harder, because people that do prepare will read all the documents. And so I do think it is important that we make sure it's manageable. And in this case, there's a classic case where I think with a bit of cooperation, we should be able to limit the number of documents to a pretty limited number, given the nature and range of matters that are canvassed in the hearing sessions. So I would hope that we can really hone it down to ones that will be of value and relevance to the decision making. So, and we're quite happy to coordinate that with the council.
Okay, thank you. Any other comments from the council on that?
Nothing to add to any of that. Thank you.
Okay, thank you very much. So we'll move on to the timetable and the dates for the submission of key documents and written statements. And I did set out an indicative series of dates within Appendix 3 of the agenda, and my note of the meeting will set out a finalised timetable taking account of discussion today. I'm conscious that firstly we've discussed an amended date for the hearing sessions, so that might just have a bearing on some of those dates which have been sort of set as dates in advance of oral process, and I might also just need to give consideration to the timescales on ornithology in terms of how timings of written submissions would give an appropriate lead-in to a hearing session on that. So perhaps the best thing is just for me to invite parties to comment on the dates that I've set out, but within mind, and it sounds like both parties have come into this meeting with an awareness of the potential to move the dates of the hearings. So just in terms of implications and any comments on the dates that I've put out, can I start with the applicant, please?
Yes, so the one matter obviously is the vision material. If you ask for, will be the week commencing the 7th. It's that week. I'll make sure it's not the 7th. I promise the 7th I may be able to deliver. But generally speaking, again, given the nature and extent of dispute, the statement of agreed matters might be relatively short, because in fact we haven't got wide-ranging disputes about context, etc. So I think the extent to which they really focus stuff that's already very focused is perhaps a point as to whether that is actually going to. We already have a very focused objection, particularly on landscape and visual. I still think it's worth pursuing to see if there's anything that we can agree that would be helpful. And certainly in relation to the policy matters, it might be helpful just to again agree a range of matters, because that's less, because it's not a ground of objection per se. There would be a value in that. So we're relatively happy with the timetable, but I think probably the one bit that would be happy with is if the ornithology got flexed a bit, in the sense of it might have to be pushed out to a bit further, because it has to allow time for our submission, a response from NatureScot, and we might well have issues that we would want to speak to NatureScot before, if there needed to be any procedure. So just thinking it perhaps doesn't immediately, might not sit, it might sit on its own with timescale potentially. It might work better, otherwise everyone's going to be forced into a position that might be too early. And I don't think NatureScot will thank you for saying that they've got to contribute to a core document list by the 2nd of April if they've only just received a submission. So I think that would be the only comment, if we could have greater flexibility around the ornithological aspects. But apart from that, in general terms, we're keen to just get on, get the framework agreed and resolved, and also to keep it quite simple. So against that background, I think the rest of it is achievable within the timescales you set. Equally, I don't think we've, if we only got 3 weeks in advance of the hearings, given the nature and extent of them, I don't think that would cause us a problem either. If there had to be a slightly shorter period in advance of the hearings. These aren't wide-ranging, lengthy topic matters, and in respect of the hearings on conditions, etc., that we anticipate that to be narrow. So the longer we get to perhaps agree those and submit that, better. But apart from that, we're comfortable with the programme.
Okay, thank you. I'll invite the council to comment in just a second. I'm just sort of looking at diaries, and my suggestion of hearing statements 6 weeks in advance of oral sessions, which would effectively take that date if we're running with sessions towards the end of May, that would take those statements into the middle of April. And I'm just wondering whether that's achievable or possibly slightly too early. I'm also conscious that that is around the Easter holiday time.
Yes.
So any before I move to the council, any specific comments on the timetable for hearing statements?
We're happy not to have them 6 weeks advance, and if you are too, then I think we can accommodate it if it was 5 weeks or whatever. I think the key is trying to get all as much as we can agree. I still think these hearing statements are likely to be relatively brief and focused, and therefore equally I don't think it's going to require lengthy preparation. So I would hope that that would probably make more sense than trying to force something on an Easter deadline, which probably wouldn't be as easy to achieve.
Yeah, okay. I'll certainly have regard to the Easter holiday when finalising dates. Can I ask the council to come in now, please?
Thank you. So, yes, I think that there's no need to stick rigidly to the period in advance of the start of the oral sessions, 6 weeks and 8 weeks and so on. For the reasons Mr. Innes has said, I agree with that, and certainly they could be closer to the time, commensurate with your own ability to keep abreast of matters. Quite content for them to be a shorter deadline in advance.
Okay, thank you. That's fine. I'll give that a bit of thought just in terms of the new dates and just making sure I've got enough time to review matters and prepare agendas. But I think if there's broad agreement on the scope of these sessions and they are relatively narrow, then I think I will be able to bring the dates closer to the dates of the session. In terms of closing submissions, I would expect any closing submissions to be in writing rather than as part of the oral submissions. We can perhaps agree that during the oral process, but I would anticipate that for the council they should be submitted 14 days after the final day of any oral sessions, and for the applicant they should be submitted within 21 days. Finally, on this point, you might be aware that DPA has been trying to speed up the process of writing up reports for ministers. So as part of that, it would be extremely helpful if parties could summarise their case, particularly in this case, if the witnesses for the landscape and visual elements could provide summaries of their cases. That essentially forms the party's voice to ministers in the report. So again, that might work best as part of the closing submissions, and we can perhaps agree that nearer the time as part of the oral process. Are there any comments on that point just at this stage? No. So moving on then to item 8 on the agenda, which is site inspections. So I intend to carry out unaccompanied site inspections between now and the date of the oral sessions. I'll visit a number of the viewpoints and locations referred to in the application and consultation responses. As indicated in Appendix 3 of the agenda, I anticipate this will include a particular focus on viewpoints where the applicant's environmental impact assessment predicts significant visual effects, namely viewpoints 2, 4, 5, 7, 9, 11, 13, 15 and 16. I'm aware that one of those is subject to change in forestry, but it's a potential significant effect. At this stage, I've not identified any locations where I consider that I need an accompanied site inspection. If parties consider there are locations that I should visit that would require me to be accompanied, I would invite comment on that today, just to outline why that would be the case, or alternatively, if anything occurs to you on that front, then I would invite that in writing within 14 days of the meeting. So I suppose my questions in terms of site inspections, are there particular locations beyond those that I've outlined that the parties consider I should visit as part of my unaccompanied site inspections? And are there any access issues at any locations that I should be aware of? I'm not aware of any from what I've reviewed so far. And then the next question then is, are there any locations where an accompanied site inspection would be necessary? So if I can invite the applicant to come in first, please.
Generally, sir, we're comfortable with the places that you're proposing to go. I suppose the one point we wish to sort of make is that it's probably quite important to at least understand the context of the viewpoint. Is it one that's actually being used for an experience on a road, rather than a might call a sort of fixed viewpoint? That's relevant in this context. And in that regard, to understand that where we have picked potential location of viewpoints, they tend to be at the one most or the most open, and then to go and experience the trip that is representing. And that's just a general point that we'd want to make. Others are more fixed viewpoints, and it's just that general point. In terms of other matters, we don't think you need to be accompanied per se, but you probably should at least go to the site. And the question is how, I mean, there's nothing really that we really want to point out that bears on any of the topic matters, but it's just a question mark of, I think, there may be aspects of orientation and understanding context where it be, but I don't think it's one that effectively needs, expert witnesses pointing things out to you. But physically, if we could make that happen for you, it might be quicker and more efficient. But that's all. And I think the only context is that if we were arranging that, if you were arranging transport ever, you might want to at least know there was some representation from the council present to allow that to happen. But I don't think that's a timing that would suit you, sir. It's probably not required necessarily at this stage in advance of the topic matters that we're discussing. But if it would perhaps require some logistics to say where we'd suggest going, and also would the council have somebody that would be available to accompany it if there was and it really would just be to get you up on site, and you could orientate yourself and understand the site and its context. And that's really all that we're thinking that might be required. But at least then you would have some appreciation of the site itself. But nothing on the matters that really turns on it arises from that. But it's just that general point of getting up onto these sites often is the hardest bit of it. And we could probably make that easier if you could liaise with the council.
Okay, does the council have a view on that point and on any other points in relation to site inspections?
Well, I think in general terms, the position would be that it's not necessary for you to be accompanied during your site inspection. I appreciate what Mr. Innes is saying, and therefore, obviously, somebody who's come from the applicant, and it would need to be matched by somebody from the local authority. But I wouldn't see that that's something that would be necessary. It might become something that you would feel particularly important once you've been through the hearing session, in which case, obviously, we'll do everything to accommodate that. But at this stage, I don't think it's something that would ordinarily be required, and we're quite content for you to carry out unaccompanied site inspections. In relation to other matters, I very quickly noted everything you were saying with regard to the viewpoints you were going to look at. And then I looked at the terms of the objection, which were drawn from the committee report. And I suppose there's just two matters that arise, is that clearly the matters with regard to the layout of the turbines is the important point of the objection. And that those are therefore specifically mentioned as turbines 2, 8, 10, 13 themselves, and 1 and 2. But also, though, the interesting thing is that at the second point of objection, it actually specifically mentions viewpoint 4, which out of the many viewpoints you did list, it didn't include viewpoint 4. So it seems to me that would be an obvious one for you to include.
Yeah, I'd certainly intended to list viewpoint 4, so if it's not on my list, that's an oversight on my part. But yeah, that is the folly above Inverary Castle, isn't it? It's viewpoint 4, so that's certainly one that I would intend to visit. Just to be clear on that, yeah. I mean, I think, yeah, thank you. I suppose reserve judgment on visit to the site itself and how best to do that. What might be helpful is maybe following this meeting, if the applicant could submit, because particular locations within the site or possible ways, I'm certainly more than happy to walk to places I've noted from mapping the presence of tracks in certain locations and so on. So any particular vantage points within the site that help give that overview might be useful to know in the first instance. And then if I feel that there's a need to arrange something further, then I can do that at a later date. But if I'll confirm the note of the meeting, but if I can just give advance notice that I'll request just a bit of steer on any particular locations within the site itself, that would be helpful. Okay, thank you very much. I think that almost brings us to the end of the agenda. Item 9 is just a few miscellaneous matters. In terms of the DPA contact, you'll already be aware that Rebecca Davidson is the case officer, and she will be your main point of contact during the process. She'll be liaising with me as necessary to ensure that documents are circulated or made available on the DPA website as required. In terms of the note of this meeting, as I've already mentioned, I will issue a note subject to other commitments that will hopefully be within about a week after today. So finally, item 10, just any other matters. Is there anything that we've not already covered that any party wants to raise just now? No, nothing from anybody.
Thank you very much.
No, thank you. Nothing from me.
Okay, thank you very much. So in that case, thank you very much for your attendance and participation today. And I will no doubt see you again, probably in a virtual session towards the end of May. Thank you very much.
Thank you, sir. Thank you.